really valuable type of right to have, and
Okay.
certainly at present it's a very simple type of right to get in the UK.
Okay. Okay. So when we say design right or design registration, just for maybe some people that don't know, and even for my clarity, what are we talking about here? What does it exactly involve?
Okay, so design right is used as a general and Patents Act in 1989, and that protects a slightly different area with a slightly reduced um,
Okay.
uh, time period in comparison to a registered design, but also courtesy of Brexit, we have taken on an EU unregistered design right, and this has now existed in the UK as a supplementary unregistered design right, which again has a very different regime to original UK unregistered design right. So we have this very complex web at the moment, with a
Hmm.
slight twist thrown in with some copyright law that covers works of artistic craftsmanship. And there is
Right.
actually a big consultation underway at the moment with the Intellectual Property Office that closes tomorrow, because they're looking at making a number of changes to the design rights system in the UK. And one of those is to try and get some clarity and some streamlining of these different regimes, because it's complex.
Hmm.
And when you've got the advisors who are sat there saying it's complex, I fully appreciate that for people who are not experienced in this area of law, it's going to seem like a complete and utter minefield. So there is this big desire to simplify the process, as well as to make some other significant changes to the system.
Yeah. Wow. Yeah, naively, I didn't appreciate how complex the system was that kind of sits behind design registration. I think maybe the assumption, certainly for me and possibly for others, is that patenting a product is a highly complex process and very involved in getting a patent granted, and that maybe in some instances design registration or design rights kind of easier. It's almost like it's maybe even lower valued in some cases that it may be considered. So I don't think I appreciated the infrastructure that sat behind it and some of the complexities. But would you agree with that observation that may exist out in the market? The difference between design registration and patents, and the fact that maybe they are the child of the IP world.
Yeah, so they're sometimes referred to as a Cinderella right,
Okay.
because they're kind of completely undervalued. Um, so firstly, we have in the UK what is often referred to as a deposit system. It's relatively inexpensive to get a design registration. And so quite often people think, well, look, we just need to throw in a few images, pay a little fee, and we've got a design registration. So that tends to be the first error. And then the second one is also that I don't need to worry about what my product looks like. I'm just worried about how it works. That's the thing that I need to protect, or I need to protect the brand. And actually, we make a lot of buying decisions on what things look like.
Yeah.
So what your product looks like actually can be very relevant. And although design registration is about external design features,
Okay.
unregistered design protection under the UK unregistered design rights system also protects internal features of design. So again, this is where the intricacies of where these rights sit, and how they overlap with each other, can become quite complex.
Okay. Okay. So a registered design right is when you create a product and you put it out into the market, and that visual or that form is novel in nature. And are you suggesting that you automatically have a right over that particular form without even having to go through a registered design process? Is that correct?
There are some rights. They are shorter in term. They're governed by a different set of
Right.
rules.
Okay.
And there has to be actual copying for there to be infringement. Whereas if you have a registered design, something that is independently created, not actually copied, can still be an infringement, be registered design. So there are some differences there. And also, a registered design has a much wider scope of things it will protect. So the UK unregistered design right system only protects features of shape and configuration,
Okay.
whereas the registered design system also protects things like pattern, ornamentation. It extends to things like graphical user interfaces. So
Okay.
it's got a much broader ambit. So it often gets applied to things like packaging and things like that.
And so when a design registration is filed, what needs to actually be shown? Because I know that, maybe we'll come on to this shortly, but there has been lots of historical disputes where maybe some design elements haven't been included, or people assume that they have been covered. So when you're advising your clients on preparing or getting together the documents to file a design registration, I mean, what should they include? How do they provide that? Is it a 3D view, multiple angles, like an isometric drawing, or what's the best way to provide that imagery?
Okay, so there are a number of different formats that are quite acceptable, and it could be line drawings, it could be CAD drawings,
Okay.
it could be photographs. There are some basic rules, don't have extra things in there. We've seen plenty of them where people have put their product on a patterned cloth, patterned background,
Wow.
fingers pointing at things. That's not going to help you, because whatever is in the image is what is protected.
Okay.
And that defines the sort of the parameters and the scope of your protection. So yes, historically there have been some strange ones, but the intellectual property office are a little better now about pulling people up on those, and they do have some basic guidance on what should and shouldn't appear in images. But the thing to actually think about, and to a certain extent you need to understand how design infringement is assessed, is what is the element that is the new appearance, the new design that you're trying to protect. It could just be a part of the product, in which case you're going to want your design focused on that particular part. But also think about, what are the variations? What are the obvious variations? So don't just file one view, don't just file one version. There's an option to file multiple versions within the same application, and you actually only pay a fairly small incremental additional amount for doing that. So if you know that if you can already say, well, we could also do it this way and we could also do it this way, why not actually go and get the design protection for that? But there has to be some thought and care into what the key thing is that you're trying to protect, so that the best way to actually capture that can be thought about. And also, what those variations are. How many variations can you instantly